Hi, I'm Russell Morgan, founder of the Morgan Legal Group, and today we're going to talk about what to do when you can't find the will of your loved ones. Sometimes your deceased loved one will fail to tell their family or the will's executor where to find their will in the event of their death. This can leave their heirs and beneficiaries in a more difficult position at a time when they're already grieving. Some states have provisions written into their statutes to address the issue of being unable to locate a will. But even then, the outcome may depend on whether or not you've been able to find a copy or if no indication of the testator's last wishes exist at all. Number one, broaden your search. If you've looked into obvious places and have come up empty, try more creative searching. Some states allow a testator to register his will with the court before his death, so call the courthouse in the county where they lived to see if they did this. Contact their bank to see if they kept a safe deposit box. The bank may or may not be willing to tell you and probably will not allow you to enter it without a court order. But an attorney can assist you in your search if a safety deposit box can be located. Check with the deceased's attorney to see if they are still holding a copy of the will. Although most lawyers do not retain the original, ask close friends, business associates, and other family members who may have acted as witnesses to the will, and therefore may have some idea about where to look. Number two, if you do happen to find a copy of the will, though not the original, there is some possibility that the court will probate it, depending on the laws of the state where the testator died. Generally, proof of her signature, as well as the signatures of the witnesses, is required. You may also have to prove to the court that the deceased still had a strong relationship with her main beneficiary and never gave any indication that she wanted to change the will. Number three, the assumption of revocation. Now, one drawback to finding just a copy and not the original is that many state laws assume that the testator revoked the will by destroying the original, which is legal in most states. This is especially true if the witnesses and his family report that the will was last known to be in his possession, not left with a bank or an attorney. In this case, if you find an original of an earlier will, most states will order that the earlier will is valid and probate it rather than the copy. Number four, what to do in an intestacy proceeding. Now, your worst case scenario, if you can't find the will or a copy of the will after a diligent search, state laws treat the testator's estate as though she died without making a will. This is called dying intestate. The court will appoint an executor and will distribute her assets to her immediate heirs, according to a formula prescribed in state laws. So the bottom line is, if you've looked in the obvious places, look in the last place you would think they would keep it. And most importantly, call us. We're always ready to help.